Dean, thank you very much for that very nice introduction, and I want to thank the Philadelphia chapter of the National Lawyers Guild for hosting this event and for inviting us to speak, and to thank Drexel Law School for having us here this afternoon. I want to start by talking a little bit about the federal judges that we have now, and then tell you a little bit about we dissent and the kind of jurisprudence that it represents. And then I'll close my portion by talking a little bit about the kind of judges that I think President Obama should appoint to the federal bench. And then David will talk about some of the other chapters in We Dissent, and then we hope to leave as much time as possible for questions and answers, either about We Dissent or about the nomination of federal judges. George W. Bush has now appointed approximately half the judges on the federal bench. His last major speech before he left office, which was in Cincinnati, Ohio, to the Federalist Society, was a speech in which he talked about what he perceived to be his contribution to the federal judiciary in appointing these federal judges. The Supreme Court under Chief Justice John Roberts can now be relied upon to protect business interests against legislation designed to protect workers, consumers, and the environment, to halt the judicial expansion of personal liberty interests while expanding the judicial protection of property interests, to interpret a so-called colorblind constitution by rolling back affirmative action and school desegregation plans, to restrict access to courts by upping the ante on pleading requirements, standing requirements, and statutes of limitations, to weaken boundaries between church and state. And the lower federal courts are even more strongly in the grip of conservative judges. It's important to understand that this conservative movement in the law is not the work of one man, even the President of the United States. It's the result of decades of organizing and political strategy. All of the judges that were appointed by George W. Bush were either members of the Federalist Society or were approved by members of the Federalist Society. Many of the cases that the Roberts Court has decided in the first two terms of Chief Justice Roberts' tenure are conservative rulings that were the result of litigation brought by conservative public interest law groups. And the conservative legal arguments that have been adopted by the court were first initially articulated by conservative legal scholars. So if we think about it, the issue facing us today is only in part what President Obama will do or should do. Much more importantly, it is what the progressive legal community will do to return the courts and the law to the service of human rights and constitutional principles. A long time ago, really about 10 years ago, I had the idea of doing this book, We Dissent. This is the book. We have Chief Justice Rehnquist on the front to remind us of his contribution to American jurisprudence. It took me a long time to get the time to do the book, but the reason I originally wanted to do it was because I was struck by how many cases were being decided by the court announcing very, very conservative principles of law with either no dissents or very, very weak dissents. How many cases were being decided by the court in which really no principled legal theory of a progressive or liberal nature was being articulated by any of the justices? The other reason that I wanted to do this book is because, after all, the law does not belong to the Supreme Court. It's an important aspect of our system of checks and balances and separation of powers that the Supreme Court has the last word on what the law is. And I firmly believe in that principle, as compared to, for example, what Dick Cheney believes in, which is that sometimes the president has the last word on what the law is. I don't believe that. I think the Supreme Court has the last word on what the law is. But the law doesn't belong to the Supreme Court. And anybody in society has the right to dissent from what the Supreme Court is doing, certainly on an intellectual basis. And so I wanted to put together a book which would show what some of the civil rights lawyers in the country and what some of the constitutional law professors in the country would do if they were on the court, what a progressive legal vision would be like if decisions on the court were written by truly progressive people. If we think about how the court might change, what we would do if we were going to change the Supreme Court, what President Obama might do if he were going to change the Supreme Court, or what our vision in We Dissent is like, I would divide that into two kinds of questions. First of all, what should the judges be like? What sort of people should the judges be? And secondly, what sort of vision should they have about the law? What sort of substantive legal questions are particularly important right now? First, as to what sort of people the judges should be, I have a very simple test as to who should get to be a federal judge. I call it the Kleenex test. This is the Kleenex test. If you want to be a federal judge, when you were a lawyer, did you have to keep a box of Kleenex on your desk? Because the people who came to see you were scared and frightened and cried about their legal problems. If you didn't, you flunked the Kleenex test. And you don't get to be a federal judge. If you pass the Kleenex test, you might not get to be a federal judge either, because passing the Kleenex test doesn't necessarily qualify you to be a federal judge, but flunking the Kleenex test disqualifies you. Right now on the Supreme Court, we only have one justice who could possibly pass the Kleenex test. That would be Ruth Bader Ginsburg. None of the others even come close to passing the Kleenex test. We have a judicial system now which is populated by an elite, by people who are out of touch with ordinary Americans, people who have no sense of what it means to have your constitutional rights or your civil rights violated. If we put the Kleenex test in place, we might actually get public defenders on the federal bench. We might actually get legal aid lawyers on the federal bench. We might actually get labor lawyers. By the way, when I say labor lawyers, I mean people who represent unions, not people who represent the management side in labor disputes. We might get people who represent battered women. We might get people who represent the detainees at Guantanamo. We might get people like that on the federal bench. And that's what we need. And by the way, I think President Obama has some sense of this. President Obama said at a speech to the League of Women Voters, we need somebody who's got the heart, the empathy, to recognize what it's like to be a young teenage mom, the empathy to understand what it's like to be poor, or African American, or gay, or disabled, or old. And that's the criteria by which I'm going to be selecting judges. Now, as I said, just because you pass the Kleenex test doesn't mean you get to be a federal judge. You have to be intelligent, you have to be well-schooled in the law, you have to have an appropriate judicial temperament, you have to be fair-minded. And I think there are some substantive legal problems that we have right now as a result of all the conservative judges that have been appointed to the bench by the string of Republican presidents that we've had, and by the enormous efforts that groups like the Federalist Society have made to influence the appointment of federal judges, and those problems need to be addressed. David and I could give you a list of 100 problems, but we don't have time for that, so I'm going to pick 3 problems, 3 that I think are among the most important problems we have, and in the next few minutes I'm going to describe those problems, and those happen to be some of the problems that we've addressed in We Dissent. The first problem is we need judges who will respect remedial legislation that's passed by the Congress, who will respect the democratic process, who will respect the fact that a majority of democratically elected legislators have enacted remedial legislation to address problems that consumers have, to address problems that the environment has, to address problems that working people have.